Good morning. Welcome, everyone. Welcome to Cyberweek 2019, day 2. I'm very, very excited about our session this morning. We were just talking before everyone arrived. This is the most international session we're going to have during Cyberweek. It is 7 a.m. in California. It is 10 a.m. in Massachusetts. It is 5 p.m. in Israel, and it is 11 p.m. in Singapore. So we are literally encircling the world this morning. And, it's a group of really, really great people, and I think this is going to be a fantastic session. So,
all women, aside from you.
Well, I like to think I'm an honorary woman this morning. Let me just do some quick introductions of the great people that we have on the panel. First, we have Dorcas Quek. She's an assistant professor at Singapore Management University School of Law. She graduated from the National University of Singapore in 2003 and obtained her LLM from Harvard University. And she was a visiting researcher at Harvard Law School under the legendary Frank Sander, who is widely regarded as the father of the mediation movement. Dorcas's research in the nascent area of mandatory mediation was published in an article that has been cited globally by many, including Lord Justice Jackson in England. Dorcas has also been a district judge in the Singapore State Courts for almost 7 years, where she's conducted mediation and early neutral evaluation for civil and criminal cases. And she's been accredited by the IMI, the Singapore International Mediation Institute, and CEDAR in the UK, and the Singapore Mediation Center. So great to have you with us, Dorcas. Thank you so much.
Thanks, Colin. Thanks, Colin.
We also have someone that many of you know, Orna Rabinovich-Einy. She's an associate professor at the Faculty of Law at the University of Haifa. Her expertise is in ADR and ODR and civil procedure, with research focusing on the relationship between formal and informal justice systems and dispute systems design. She's a fellow of the Haifa Forum of Law and Society, the Haifa Center for Law and Technology, and NCTDR. She holds a doctorate in law from Columbia University, and she was admitted to the bar in Israel and New York, and was certified as a mediator in New York by the Safe Horizon Mediation Center. Many of you also know her as the co-author of Digital Justice with Ethan Katz. So, Orna, thank you so much for being here. And then, of course, we have Leah Wing, who's co-director of the National Center for Technology and Dispute Resolution. She's a senior lecturer in the Legal Studies program in the Political Science Department at UMass Amherst. She serves on the faculty of UMass Amherst, where her research and teaching apply critical theory to ODR, mediation, and truth recovery and reconciliation in colonized and post-colonial societies. Leah's been a mediator since 1983 and has trained everybody. She's been on the board of every dispute resolution organization. Her research is incredible. All of the standards and work that we do at ICODR, at the International Council for Online Dispute Resolution, is based on this deep well of research and work that Leah has done over the years. She's received the Award for Distinguished Service to the Field of Conflict Resolution from the Association for Conflict Resolution, and the JAMS Award for Outstanding Publication in the Field of Conflict Resolution. I could list her awards and accolades all day, but we got to get into the session at some point. So it's really an all-star panel, and I'm super, super excited to have everybody here. So with that, why don't I hand it over to Leah, who I think is going to kick us off.
Thank you, Colin, for that incredibly nice intro for all of us. Welcome to Cyberweek, and I'm just going to pop up the opening slide here. We are going to talk about AI and ODR, applying ethics at key decision-making points in standards building and systems design. And we also, if I can get this to work, as Colin has so kindly mentioned, the introductions to the three of us, and here are the names of the short presentations we're going to give.
Leah, I'm sorry to interrupt just one more time. If everybody who's on the call could mute if you're not talking, that will help us with some of the background noise. So if you wouldn't mind doing that, I may proactively mute people as well if I feel like there's some noise through your line, but not the presenter. Okay, thank you so much, Leah.
Sure thing. So that gave folks a chance also to take a look at the topics of presentation. We're each going to do a brief presentation and then have a chance to take comments for those that are participating on the call, either through the chat button or through a chance to weigh in with your microphone. So with that, I will stop sharing and hand it over to Dorcas.
Or is it to, would Orna like to start, or would you like me to start? Orna?
Oh, sorry, no, Orna, my mistake, apologies. Yes,
no problem.
No problem. No problem. So I'm going to talk without slides. Hopefully this will be comprehensible despite the lack of slides. And I have this fancy title, which I need to unpack, an ethical duty to learn and improve dispute systems in the age of digital justice. So I'll talk about this, I think, in 3 parts. First, I'm going to say a word or two about what is the age of digital justice in which we are positioned or entering. And the second, I want to talk about learning. And finally, I want to talk about why that would serve as, why there would be an ethical duty. So as Colin was kind enough to mention, a couple of years ago, I co-authored a book with Ethan Katch, Professor Ethan Katch, the founder of the field of ODR, and the book is entitled Digital Justice. And what we sought to describe in the book is really sort of the new dispute resolution landscape we see that is taking place these days, as opposed to what we termed the traditional dispute resolution landscape, the traditional court or in alternatives, and the shift to digital justice really removed the face-to-face element, and that not only had an impact in terms of convenience, but we think, and many of my friends I know think as well, that this has had a very deep, or is having a very deep impact on the nature of these processes and what they entail for people in terms of access to justice. And what we noticed when we were looking at this emerging digital dispute resolution landscape was that access to justice was impacted in multi-directional ways. On the one hand, we saw many new barriers in the forms of new disputes emerging. We saw that the traditional processes that were premised on face-to-face interaction were often not accessible to people. So they were left with new disputes that were frequently, that could be more frequent, larger in numbers, even if not in scale. They were meaningful to people. And on the other hand, there were no effective or very few effective means for addressing the new mass of disputes that was emerging. On the other hand, technology also proved to be and to provide new avenues for enhancing access to justice. Suddenly, there were new types of disputes emerging and being designed, new types of dispute resolution mechanisms. So these weren't necessarily mimicking what we knew from the face-to-face arena. They were looking like new types of processes. We now see triage systems in courts, automated negotiation that emerged early on in its different forms, surveys, crowdsource dispute resolution, a lot of new options to think about dispute resolution, but also new thinking over time on dispute prevention. Suddenly, dispute resolution processes that were less geared towards preserving data, some of them even very consciously trying to remove data from the table, right, if we think about mediation, but also even in open court, we weren't very good about collecting data, and we didn't care so much about collecting data. This was sort of an activity that occurred on the margins and wasn't the center of what courts were doing. And suddenly there was all this data that was being collected automatically, sometimes almost at no cost. And this could provide us with important information about sources of disputes and about the impact of interventions on the effect of resolution. And this could be used to learning. So new opportunities for learning were also emerging. And it was clear that a potential existed when we look at technology for enhancing both access and justice, and maybe even overcoming what has traditionally been seen as an inherent trade-off between access and justice, or between efficiency and fairness, because we typically see more access, more justice, and more fairness equated with sort of more elaborate processes, longer hearings, and these are sometimes in tension with effectiveness, with lowering costs, with making processes more simple. Something about the qualities of these new technologies that were being introduced into dispute resolution created new possibilities for enhancing both access and justice, both efficiency and fairness. I say potential because this is not a sure thing. This is not an obvious route to take, but with appropriate design choices, this could happen. And this could happen because of the three shifts Ethan and I identify that happened with the shift from face-to-face to online. First of all, the shift in medium, and then the shift from sole reliance on human third party to automated fourth party. So the introduction of the fourth party and automation and algorithms increases potential not only, we say, for access, but also for enhancing fairness. And finally, the shift from small data to big data, which I mentioned before. So that's sort of the background of what is this new landscape, what the new landscape of digital justice entails. And I want to say another word or a few more words about learning. So when I say learning, I mean a commitment to studying past performance in dispute resolution and evaluating the impact of design and performance of the dispute resolution system, processes, third parties, fourth parties, in order to improve how these processes and people or algorithms function, but also how to improve the interaction that gave rise to these disputes to begin with, so that these disputes do not emerge. So two meanings of learning. Learning about the sources of disputes through the disputes that actually show up over time, and we come to recognize them as repetitive disputes. We understand, for example, on, say, eBay, that if we see repeat disputes that relate to delivery, we might see that something about the display of information regarding delivery is problematic, and then we could learn and fix that to begin with, or learning about the impact and effectiveness of dispute resolution choices and performance. So what does it mean for us to offer automated negotiation in certain types of disputes for certain types of parties, okay? What types of outcomes does that lead to? Is that effective, or does that escalate a dispute? So all kinds of design choices about the dispute resolution itself. So this doesn't prevent the disputes from arising upstream, but it allows us to improve how we deal with them once they do arise. And originally in the traditional dispute resolution landscape, this really happened only at the margins, mostly in what we called internal dispute resolution. So within organizations where you had a group or a person who worked at the same place as an ombudsperson or as a dispute resolution designer, a dispute resolution provider, and they would over time come to learn and be familiar with this particular environment, the types of disputes that would arise, and they would be the sort of institutional memory and recognize the sources of disputes. But this was obviously sporadic. It depended on these people. It wasn't, in some cases, units or people adopted mechanisms to make this more systemic. The NIH, for example, other places, but still this was not in the magnitude of what we could achieve in additional sectors in the digital era. So what is happening now, and why do I think we should actually call this opportunity to learn an ethical duty? So it shouldn't just be a mere possibility to learn that is opening up to us, but I think it should actually rise to the level of an ethical duty. Dispute system design is not a one-shot activity. It's not static. We don't design a system and finish with it and retire. This is actually a cyclical engagement we have to constantly engage in, reevaluate our choices, see whether the conditions have changed, learn about the effectiveness of the systems we've put in place. This becomes all the more important. I think it's always been important, but becomes all the more important these days when some of the interventions are actually being performed and will be in the future performed by algorithms, sometimes learning algorithms, the impact of which we don't really know. Many of the people who design these algorithms don't really know. And it's very difficult, even after the fact, to decipher what exactly these algorithms were doing. They are a black box, as has been stated often. But what we can learn is at what stage they operated and what was the outcome of their intervention in certain instances for certain types of disputants. And this is an activity, especially given the fact that we do have a black box here, much more of a black box than the one we had when we had a mediation room. It's very difficult to discern what is happening. On the other hand, we have much more data than we had in the past. So what I think we as a community of people who are interested in dispute resolution in the digital age should commit to as a community is an ethical duty to collect a broad amount of the broadest amount of data we can, both on objective measures, types of disputes, measures of how many interventions, which types of interventions, at what stage, demographics of parties involved, and obviously outcomes. Study this type of data not only from an efficiency point of view, but also fairness. Are certain groups faring better or worse in certain circumstances under certain design choices? But also to collect subjective data, collecting different types of individuals' perceptions of fairness and of efficiency of these processes that take place, and to learn from them where machines work better than humans, what types of algorithms we want in place, where we feel we can improve and do better, and to basically engage in this ongoing learning as a constant ethical duty. Thank you.
Great, thank you, Orna. So we're going to go to Dorcas now, right?
Yes, let me take a moment to share some slides. Good. Thanks so much, Orna. I totally agree with what you mentioned about the need to really have. In fact, you frame it as an ethical duty, right? Almost like something really very important that is even more critical now in this digital era, to really see how we are going in terms of efficiency, fairness, and many other areas. Which I think this ties in with the very recent ODR forum, right? I believe that the theme was measures and metrics, boldly going where the numbers lead. Yeah, just checking in terms of sound. Is it all right? Yeah.
Yep, sound is fine.
Okay, let me just find the slides and then we'll be starting soon.
Perfect.
All right, can we see?
Yep, we can.
Yeah, so I thought that what Orna shared really ties in quite well in terms of what I'm going to talk about. So in terms of, there was a broad overview of the trends, the shifts, right, that are brought about by this digital era, and what it means in terms of dispute resolution, in terms of learning for us how to prevent disputes, as well as to handle them better, right? And then from there, then really an obligation perhaps of the community, the dispute resolution community, to really see how we can continually monitor and see the impact of these systems that are constantly emerging even now as we speak. So I'll be looking at how a specific context of court ODR systems. Well, by way of background, this is a particular interest of mine, probably because I used to work in the courts, and now in academia, I find that I often look at dispute resolution systems in the context of what Orna was mentioning, like justice, perceptions of fairness. I also look at very much at ODR and how it links to what happened in the past in terms of ADR. So of particular interest to me is really how these are used, how these digital tools, be it algorithmic kind of tools or AI tools, how they are used in the context of courts. And we well know also that a very recent book, right, on online courts by Richard Susskind actually really zooms in on this whole area of online courts, which is really online dispute resolution in the courts. I'm just showing a slide here on the ethical principles for ODR, just to say that Colin did mention about International Council of ODR or ICODA, right? So these are the kind of principles that I think we are looking at when we talk about ethical principles. So I think sometime last year in an ODR forum, we were meeting in Auckland, New Zealand, and I was actually sharing that I think some of these principles, they are even more crucial and critical in the court context, more because of what people's expectations are like when they go to court, right? Things, for example, of accountability, equality, fairness. I think it's quite undisputed that these are very important qualities. So from that angle, I was then looking at this trend, if we look at the next slide about having ODR systems, right, which we are finding they're getting more and more sophisticated in the ODR systems around the world in many different courts. This is just an overview of the common features that many of these systems have in terms of the stages, the modular stages, and how they build from one stage to the other, starting first with some kind of way to diagnose a problem, to have some triage, or to provide avenues for self-help, and then escalating as the issue cannot be resolved, escalating to the next stage, say some kind of online virtual facilitation, whether it be mediation or arbitration. And then furthermore, it still escalates and can't be resolved, and then it'll be for perhaps online resolution. So that is a basic kind of system that we have now for many online courts. Sometimes you call it stage 1, stage 2, right? Tier 1, tier 2, etc. And these are just some examples. So I was thinking about a few questions arising from these kind of systems. And we know that these are not static kind of systems. Like Orna mentioned, they are bound to be changed in the future. We might have the algorithmic tools that might be provided by the online courts. Perhaps when you're negotiating, some kind of tool to help you negotiate better by providing you with certain information, certain data, right? So these are all amenable to much greater change in the future, and this is just going to be rapidly changing. And then this slide just shows the logic behind it. So I very much appreciate the writing on about the dispute systems design, and I totally agree that much of these principles about dispute systems design really underpin the design of ODR systems. And this is what we should be looking at. In terms of logic, I suppose this is the logic that is underlying many of the court ODR systems, right? The idea of dispute avoidance or prevention. And then you notice using more resources for more complex disputes that cannot be resolved at the earlier stage of tier 1. So there have been two things that I've been thinking recently, mulling over them, and also looking at as the changing landscape, how some of these issues might be even more pertinent in the future. One of them is, as you can see, these 2 points. The first one is really, well, do we have a seamless track within online courts? Or do we actually have distinct kind of dispute resolution processes? And I'll elaborate in a moment what kind of issues crop up out of that. The other really is subject to lots of rapid development now, the sense of not just having online facilitation, but moving on to say if we have algorithmic or AI kind of tools that actually will be used by the courts in decision making. What then is the impact? So that is something also being discussed. I think it was also discussed by Richard Susskind in his latest book. Right. So moving on to the first one, seamless track or distinct processes. Well, in this respect, I'm actually looking at. Sorry for this shadow here. There wasn't meant to be a shadow here, right? But if you look at this slide, I'm looking in terms of actually looking at the history of ADR, right? Because how ADR is developed, and then from that standpoint, and now we use ODR. What is the impact of dispute resolution processes? So that's really the angle I'm using, and so look at this picture. Is the idea that we have great potential, right? Once architecture-wise, right? So to really design something that is seamless, right? So whereas in the past, you might go physically from one place to the other, say from a courtroom, you go to the mediation room. Now all these kind of physical barriers or distance or some kind of differences that are really very, very prominent to you, they are kind of not so prominent because we can actually seamlessly move from one stage to the other, right? And they are all maybe planned such that they seem to be progressive, right? We're not just moving out of one room and going to the next room. So of interest to me is really this idea because I think some of it has started. If you look at, say, Tier 2, right? If you just look at the second thing, mediation arbitration. So actually there's great potential. In the past, probably if you want mediation, you just go to the mediator room and then he'll give you an explanation of what mediation is about. Perhaps there's sometimes a bit of mixture. Maybe the mediation might evolve, say, met up, right? Mediation to arbitration. But let's just put our thinking hats. If in the future, it might not just be on an online forum and then a human being there, right? Perhaps you might have a tool there, right? Online tool or algorithmic or AI tool that helps you not only negotiate in the sense of a mediator helping you, but it might actually give you some kind of evaluation, right? It might give you an evaluation of what is your outcome, likely outcome to go for trial. It might supply you with such tools such that you're able to predict the outcome. So with these kind of tools, I think it's exciting because there is the potential for lots of hybrid processes, if you call them hybrid blended processes. Whereas in the past, maybe we have been talking about blended processes in terms of mediation, met perhaps, or up, met up, or neutral evaluation, right? Or so many variations about that. So I was thinking about what that implies actually for a person who's going through the dispute. Once you have the potential for lots of mixture of this kind of different kinds of processes. And interestingly, just looking at also the users in terms of preference-wise, there really is a great desire, a great preference, even in surveys. This is a Queen Mary University White and Case latest international arbitration survey. You notice compared to arbitration, this is the middle portion, standalone, preference by in-house counsel 32%. If you look at the first section, international arbitration together with other ADR processes, in other words, this is a very much blended process. There is really a demand for blended hybrid processes. So this means that this is a great opportunity for ODR in terms of how do we fashion that facilitation in terms of combining different dispute processes. So this is where I was thinking that what we could actually learn from some of the lessons from the past in terms of the development of or the alternative dispute resolution or mediation, right? We could intentionally reduce the differences between the processes, right? Such that it's just one whole process. You don't call it mediation, arbitration, etc. Or you can actually accentuate their differences in terms of telling people, we're going from one step to the next step, right? So we could actually combine them all, and then the impact on this, because this is something that actually did arise in the past also, where mediation was used, and then the role of the mediator or what exactly goes on, what exactly mediator do, as in whether you make decisions, sometimes at the start it's not made very clear to the people who are going into the process, right? So that actually involves informed participation, right? Am I aware what is involved as I go into the process? So this is where, like what Orna mentioned, if in terms of learning, design, if it's made clear, and also learning as people participate in such hybrid processes, what will be their reactions and how will they find this, whether it really meets their perceptions of fairness and is something they're satisfied with. I think it's something that deserves to be really investigated further. Secondly, this part about algorithmic AI decision making, I'll talk briefly about this. We know this is something really still in the process of great development. I think it's interesting, actually, if I just go to this slide. I was reading about online courts, this chapter, computer judges. There's a chapter on computer judges. And this is something I've been talking a lot to my students, because I think perhaps not just in Singapore, in many countries, law students are really worried about will we be put out of jobs, right? Just as judges might be worried will they be put out of jobs, such that I don't have to be there as well, right? So there's this question Saskain was talking about, trying to ask whether the way judges decide, the nature of legal reasoning, the nature of decision making, can this fashion of deciding be delivered by machines? In his opinion, he thinks that despite a great deal of hard work in this community, we are many years from having systems that, other than in very confined areas of law, can generate decisions with reasons, right? So I think now the idea is that we have tools that can predict outcomes, but whether we have tools that say if it helps a judge predict outcome, such as you say my decision is in favor of A instead of B person, can it also help me generate clear decisions, clear reasons that will justify that decision, right? So I suppose most people think at the moment we are still in the midst of developing that. Are we able to develop some way such that systems will outperform judges at their own game, delivering reasoned judgments and explanations that will look and feel like the finest of human judgments, but sourced through AI? So that actually, in a nutshell, is what I've been thinking about, because I think there's been lots of discussion. This is just one example. Most of us know about this discussion in terms of using risk assessment tools and using data to then have an assessment based on the risk of reoffending, right? So that, of course, led to a lot of controversy, because I think it's about whether the data was representative or whether it amplified certain biases, right? But more importantly, I've been looking at what happens if we use it, right? The judges use it, or what if not the judges use it, but is offered, say some predictive tool is offered to the parties as they negotiate, right? And then there's no way to see what is the reason for, say, a certain prediction or a certain outcome. So there are some issues really about explainability. How do we ensure that a decision being predicted, albeit with lots of data and very, very, very deep machine learning, how can they be explained such that there's accountability, is explainable, is transparent, right? So in this respect, I think there's a distinction between predictive tools and what we're talking about giving reasons. And interestingly, lots of predictive tools we have now, these are just some examples, they do not they do not predict results purely based on legal grounds. A lot of the predictions are based, say, on other factors, other extra legal factors, maybe the judge, right, the subject matter. And these are already available and being used by lawyers, because we might well use it to decide whether to settle, whether to negotiate or not, or whether to go ahead. Right? The big question which I've been pondering about is, at what stage will such tools be developed such that you can also justify with reasons, such that you not just predict the outcome, but you also can, say with a computer judge, also explain why this outcome was reached with reference to precedents, with reference to legal principles, etc. So in conclusion, it's really the issue about transparency. Orna mentioned about whether it really is a black box. Can we find some ways to actually make use of the big learning there? Because there can be lots of learning to generate and actually predict an outcome, which might also overcome certain cognitive biases within humans. But can we find a way to really overcome that black box such that those decisions can be explained, perhaps with even some AI tools, in a way that can be grasped by human beings who are listening to the explanations? So I was just looking at some writings, but this is of course not my area of expertise, computer science. So there have been lots of developments. People are trying to find, using AI tools themselves, to find ways to actually overcome the black box problem, to actually deliver justifications, right? So those are the two things I've been talking about. And some of these have been, some of my musings have been in these two articles so far. And yeah, so that's all I'd like to share. I look forward to also hearing a lot of the comments. Thank you.
Thank you so much, Professor Quek. And if I'm able to, I will now shift and share my presentation. So I will talk about ethical and unethical uses of AI in ODR, putting ODR ethical principles into action for standards creation and systems design. Key points I'll say at the beginning, which I hope that will be clear by the end, is that artificial intelligence magnifies opportunities but also risks in access to justice, and that ethical ODR standards, systems design, and monitoring are essential for this, which I think I'm an echo chamber for my two colleagues. I want to pose that ethical principles for ODR can serve as a GPS for standards creation and systems design. Just highlighting what I think so many of us already have talked about and so much of the literature has stated is, I tip my hat very much to Orna and Ethan Katch's book, Digital Justice, which does an in-depth overview of the information I'm gonna kind of highlight in the next couple slides, is that technology really can enhance efficiency. And we see that all over the place, whether it's in dispute resolution or in other aspects of our lives. As Orna has mentioned already, it can be incredibly useful for dispute prevention and detection, even if it's not officially part of a dispute resolution system. Frankly, every e-commerce application that is designed to try to prevent disputes so a company doesn't have to deal with them and the consumers don't have to deal with them is inevitably a part of a dispute resolution cycle. So technology has been very helpful for that. And it can contribute to the handling the complexity of case management as well as contributing to creativity. I know there's a lot of debate about whether when we take humans out of the mix entirely, we lose a lot of creativity, and that's a legitimate argument, but it also can provide new ways of thinking, especially when we have highly complex cases. We also have the increased risks that are AI driven, I would argue. When we have a lack of transparency, this inevitably leads to a lack of accountability, and both my colleagues have already spoken to that. It reduces our ability to ensure that the processes are ethically driven. In whether it's ADR itself, whether it's courts, or whether it's entirely online systems. And therefore, as a result, it reduces procedural and substantive justice. And again, I point to some of the work in Digital Justice by Ethan and Orna that highlight that when we collect incomplete data or inaccurate data, it really compounds the problem when we use that for machine learning or for systems design. So often that happens unknowingly, but I'd like to offer that sometimes, unfortunately, we have systems players that set it up purposefully so that it assists repeat players, it assists business or government or other entities. So those are some of the dilemmas that we face when we're looking at systems design. Move this out of the way there. So we have a set of old ethical concerns that for decades we've been challenged by. How do we deal with power imbalances? How do we deal with the preferences for repeat players, their familiarity with systems, with processes, and actually with human interveners? And those are not, there are a lot of creative ideas out there, but we still have debates in the field about how to handle that. But now we have a whole set of new ethical concerns because we have new input points, we have new ways of gathering data. I just mentioned some of the ways in which we can misuse data intentionally or unintentionally. And also, we now have as Dorcas has highlighted, we have this integration into systems that's going to cause changes to systems. That's both exciting and can make things more efficient and have more creative possibilities and options, but it also leads to a greater lack of misunderstanding or a lack of accountability inside those systems. So again, I'd say I want to add my voice to the clarion call for the need for ethically driven systems. I'll just take a brief moment to say that there's a lot of literature out there on what principles are and what standards are, and they're often used in a layperson way rather interchangeably. So I just want to highlight a difference in the way I'm using them. Framing principles as overarching values and standards being framed as actually rules-based. So we can measure whether systems live up to those rules or whether practitioners, whether they are AI, digital, or human, whether they're living up to those standards. So I want to point us towards a set of ethical principles for ODR that are a list of shared values, not rules, and say that they hopefully can be helpful to guide us as we develop standards together. I also would say they can be useful even once we have standards, because technology changes so rapidly that when we finally agree on a set of standards and they are relevant to whatever sector or jurisdiction or culture in which we're using them, technology is going to continue to change. And during the time that we have new technology that don't match standards, we can once again turn to principles to help guide us as we continue to develop our system. So you can take a look at these particular ethical principles for ODR at odr.info, at the National Center for Technology and Dispute Resolution website. It's really a misnomer. At one point in time, the name was needed, and yet we have 40 fellows from around the globe. It's truly international, and these principles are hopefully very relevant and flexible to work in different jurisdictions and cultures. As I mentioned before, they should look rather familiar to you because they're based on the shared values of ADR. But when you take a look at them, each one is 1 or 2 paragraphs long, and they're explicitly related to technology. So they are thinking about how our ways of handling disputing with the use of technology will address these values. So now let me jump into applying them. Let's start with an example. Picture that I mediate and I say, now let's use some technology because I've got parties at a distance, or the parties might find it more comfortable to not meet in person. So for a variety of reasons, we may incorporate this as part of our face-to-face process by having some work done online asynchronistically, or we might do all of it online. And so in the absence of ADR standards that apply technology, I may say, let me use the typical ADR standards around voluntary participation and around confidentiality. Now, doing that arguably actually raises risks for parties, and I would say therefore also for the human intervener. If I only require parties at the beginning to say, yes, I'd like to participate, I voluntarily choose to participate, yes, I agree that you will hold this confidential, or perhaps they themselves will agree to hold it confidential. Let's take a look at some of the risks that emerge under those circumstances. In our example, if just clicking yes at the beginning, it might mean that the party, and I'll speak to something that Dorcas mentioned about informed consent, may be that the party is just assuming we're just going to actually do document transfer online. And then we will be over email or some form of chat communication, we'll be typing. They may not have thought ahead that we may use video conferencing. And the human intervener may not be sure. As we're going through the process, they may not be sure what technology they're going to find. But at some point, we may choose to use a scheduling device, let's say, that has location features. And parties will be using that potentially without realizing it has location features and that they have not agreed to that. They may be required or invited to use software which one party is more familiar with or more adept at using than the other party, and this can increase an imbalance of power. And by clicking yes, they may actually be waiving their right to court. In many countries, that's the case outside of the European Union. And they also might be agreeing inadvertently to use a process that is guided by machine learning, by algorithms, or even maybe providing options or a decision without their consent. So how can I apply an ODR ethical principle or principles to this example as a practitioner? Well, if I looked at that list and I read through them, they not only point towards each other to help me think about the relevant principles to use, but they could provide me some guidance to create my own protocol. So for example, I might develop a practice protocol where I think through all the types of technology we're going to use and what the risks are, and that I state that to the parties up front and answer questions and then make sure that they're informed and they're voluntarily engaging in them. Or I might say, I promise you that when I introduce a new form of technology, I will discuss that with you. So I'll give you a moment just to look at what the principle of confidentiality says. The development and implementation of ODR systems, processes, and practitioners maintain confidentiality in accordance with all legal obligations and in a manner that's consistent, in particular, with the principles of legal obligation, informed participation, security, and transparency. So we can see here that this is an example of the principles pointing to others that are interrelating that you might want to consider. And then here's the principle of informed participation, and it is based actually on medical ethics. When someone goes for an operation and they must say, I understand what the operation risks are and I agree that I'd like the operation. So using medical ethics to create a principle of informed participation for the use of technology with ADR or ODR, we have 4 different steps, and 2 of them I highlight for the example I'm discussing with you. One is the explicit disclosure to all the participants about the potential risks and benefits, and the other is to make sure that they're voluntarily accepting these risks. So now I'll just turn to how can we apply ethical principles to software design. Well, in the absence of shared ODR standards, but with an interest in informed ethical application of technology to dispute resolution, I know of 2 examples where 2 different groups are working on this. One is an app development team that is creating a protocol within the software design based on the principles of legal obligation, informed participation, and security. And the other is an ODR startup that's using the accessibility principle to structurally determine pathways for a variety of forms of decision making. That way their platform will be responsive to different ways of decision making and some of the research on gender and culture. So here's the principle of accessibility that they're using. And here I highlight that accessibility would require that the design and implementation of efficient and effective processes provide for their usage, not only for the broadest range and number of people, but also by accounting for the reality of cultural differences within and between jurisdictions, the differential access to resources, and the experiences of marginalization. So if we have that in mind, right, that can help us to make decisions about software design, platform development, employment of AI, etc. And I'm lastly going to just give you a brief example of how we could use ethical principles to help us construct standards. First, I'd point out that we might want to identify a target, and I know Janet Martinez is on the call. We've had a rich discussion about this, and I thank her for her contribution to these ideas. We want to identify for whom is the standard. We may find that we can create a standard for all of these across the board, but my guess is that they may be need to be fine-tuned depending on whether you're talking about making a standard for AI or a standard for a whole system or a standard for a human neutral. So if we wanted to create a standard related to accessibility, then I pulled out, you can see on the screen, some of the key components of the principle of accessibility. And then if we're, again, it matters who you're thinking about the principle, the standards for, is, for example, if we're talking about a court or we're talking about an e-merchants ecosystem, then if we're trying to create a standard for that particular context, would we be thinking about accessibility? How would we be thinking about accessibility based on where ODR is connected to the rest of that system, right? It's going to matter whether it's a separate track, about whether it's embedded in the larger system, whether it is, as Dorcas mentioned, whether it is part of a hybrid system or whether it's really separated out. Where is it listed? How will people know about it? At what stage of the process that they're involved in, the buying or the selling or the application of a complaint to a court? In what way is it made visible? Because accessibility issues are directly related to that. What about costs for participation for public dispute processes in particular, et cetera? So I hope that this can show that the ethical principles can be useful at different points in our processes for actual human practitioners, for the development of standards, and also very importantly for systems design. You can find these ethical principles at odr.info, and as has previously been mentioned by several people, the International Council on Online Dispute Resolution is a membership organization that you all are welcome to join. And they are working to apply these principles to the development of standards, and there's a set of standards that are listed there. Thank you.
Fantastic. Thank you so much, Leah. Okay, great. Wow, that's incredibly rich range of presentations. So I think we want to open it up to the participants. So do people have any questions or points of clarification they would like to focus on? I'm tempted to cold call on people. But it looks like Barbara Wilson has a question. So please, Barbara, you can unmute and ask your question. Or you could just type it in the chat, whatever you would prefer. We did have a comment before from Robert, who said, for companies, there are two key issues that legal departments have difficulty with. One, organizing the case data, despite having case management software, and two, having a more detailed methodology on how to develop settlement policies that are equitable and at the same time align with business objectives. So I don't know if anybody wants to tackle that before we hear Barbara's question.
Well, maybe I'll just say that this is, I think this is exactly the challenge we're talking about, that when private companies, or it could be a public agency or a court, when they design their dispute system, they need to also think of how they're going to deal with the data, and to think of this as an ongoing activity, and what it would mean that they actually discover in the data that certain avenues work and others do not, and how they intend to incorporate these lessons. So there needs to be, in a company, to study the data, to collect it, to make sure they have mechanisms that are effective in capturing the right kind of data, and then how to study that data that is captured, and then how to implement the lessons that emerge from that data. It is a challenge. I think the first phase is recognizing that the challenge exists, and then assigning responsibility, accountability, as I think Dorcas mentioned, for handling the data and incorporating it into the system design.
Great. And I see Robert did just post a follow-up, but Barbara, why don't you ask your question first? Unfortunately, Barbara, we can't hear you. It does look like you're unmuted, but I'm not sure. So it might be a better idea to type your question into the chat. So let's go with Robert's follow-up. Robert said, Leah, what did you mean on your slide when you said that algorithms can impact outcomes without consent? If a user is negotiating a case through an automated platform that relies on algorithms to be automated, by definition, aren't they consenting?
So sure, if it's quite clear that they're using a process that uses AI, then they may be consenting to participate in a process that uses AI. However, not every, what I would say is there are systems that could be actually offering different types of ODR processes to different types of participants. And that could be defined in a merchant's ecosystem, just for example, based on how much money they regularly spend with a merchant. And so the participant may think that they're getting a fair process or the same process as any other client or any other consumer, and they may not be getting that because the system may route them through a process that's different than others. So we need ethics to either make it transparent so that people realize that they're participating in a system that is not designed the same for everyone else. So then it's their choice, or we need to decide as a larger community or as societies that we don't want to allow people to have different access to different processes, whether they're government run or whether they're from the private sector. So I guess there's multiple layers around what informed consent means. There could be an agreement that we will use an automated system, but that still doesn't mean that there aren't ethical dilemmas built into that. And also I think that there are times in which people are engaged in using a process when they don't know that there's machine learning that's being used behind the scenes that's impacting the process design itself. Great question. I appreciate your comment.
Yeah, and also a good follow-up from Yam, who posts in the chat, how can we ensure that informed consent is possible when deep learning is often not easily explained, even by the software designers themselves?
It's a brilliant question. I invite my colleagues to also join in on the conversation. Any thoughts from Orna or Dorcas on that?
Yeah, I was thinking about what you're saying about informed consent, Leah, and I was thinking, yeah, I think along the same lines, there are struggles. Say, if you really want to have informed consent, there were two things that you pointed out. You need to highlight perhaps the risk, right, and then get the voluntary consent. So for instance, this relates probably to Yam's point. How are we going to highlight the risk, or perhaps highlight or explain that there's some deep learning involved here? So the usual objection would be, I can't even explain deep learning. So how am I going to explain to someone such that that person can consent to it? So this is something I also been wondering, how much do you explain, and then so that it's really apparent to the person what it means, and how do we highlight the notable features? So all I could think of is maybe really highlighting those that are really, really notable things that might have an impact. And to the extent that we can explain what is being used, what machine learning is being used, the impact on the person, just highlighting those points. I'm wondering what both of you think.
I actually, this is a conversation I've had several times with people. We talk about how ODR is focused on procedural justice. And the thing is, with machine learning, we don't really understand the procedure. It may be beyond our ability to even comprehend what's going on inside these algorithms. So we only can evaluate the effectiveness of these machine learning mechanisms by their outcomes. But that's not often a possibility for parties, because they only have one case. So it does seem like this is a significant issue. I mean, we need, and that's one of the reasons maybe why I think an organization like iCoder is important. If we can go in and look at the data and do an audit and look at a large number of outcomes, we may be able to say, yes, this is a trustworthy AI. But an individual party that's sort of beyond. So I think the question that Yam asked is great. How can you consent to a process where you don't even understand what the process is? And it may be impossible to explain.
Exactly. I agree. And I think, you know, in this context, certainly, and in other contexts as well, I think that transparency is sometimes overrated. It's certainly important, but the question is at what level? So we're not going to get informed consent here that people actually understand exactly what's happening, because the people who designed these processes don't understand exactly what's happened. We've heard Facebook say, well, we don't really know what our algorithm does, right, in certain contexts. So this is, and I agree with Colin, the only way here we're going to sacrifice some of the informed consent, or at least informed consent as we've known it thus far. We would color it with a different meaning, with different content. We would inject it with different content, and that content might be auditing. So they would have to disclose information about the kinds of audits this process has gone through. So it would look differently. And to be frank, you know, informed consent has had its limitations in other contexts as well. If we looked at what's happened in the medical context, where we also have algorithms, right? But it's very difficult to know what you're agreeing to. And sometimes when you read the fine print, you don't really want to agree and you don't really have a choice. So
that's right. And that may be where this goes, is you don't really have a choice. These algorithms are used on the back end and you don't even know they're being used.
Exactly.
And I want to point out, Robert made a great, and I'm sorry, Leah, please.
I probably was headed in a similar direction. I was going to say, one thing I want to make as a plug, I think that I have made it clear already, but one thing I'd like to say is I do find that there is a need for standards. And they're valuable for many different reasons, for protecting all the parties involved, and for us to try to create the most equitable set of processes and opportunities for whether it's healing or for transforming relationships or for concrete outcomes. At the same time, the questions that we're talking about, as far as I'm concerned, they don't all have a perfect answer. And because we are, and this points to, I think if I could just try to speak to Robert's next point in the chat, is that I cannot picture how we could have the same exact standards for every jurisdiction, for every type of technology, and for every cultural setting. At the same time, we don't even have all the exact same standards for arbitration as to mediation, just as an example. At the same time, when we have an ongoing living set of ODR ethical principles, these are the discussions we're having here, are the discussions I hope people are going to have as they design their platforms. And I hope that practitioners who begin to use technology more and more will have with themselves and with their colleagues as they figure out the protocols they'll use. So the standards are very important, but they're not the be-all, end-all. And so these are rich, important discussions that I think can make a greater impact when we continue them. That's what I'd say.
Yeah, I echo that, because I think that wrestling itself with these kind of questions is something that we have to do. And of course, how it applies to each context might well differ, but I think we probably have to think, for example, the principle of informed consent. To what extent is it feasible? Right? Of course, it depends on what kind of technology. To what extent is it feasible to really explain such that the person does know the largely what the impact could be on himself or herself? Yep.
Yeah, if I could just piggyback on that too. I mean, I love what you presented, Leah, about targeted standards, and I think we do need to get very specific, application by application. I think what Orna said at the last iCoder meeting we had is, instead of just coming up with standards, we should also come up with questions, which is like, hey, if I'm somebody who's building an ODR platform, what questions do I need to ask myself about each one of these standards to ensure I'm in compliance? And one of the things that I've aspired to is making these standards so simple we can put them on a laminated card and make them objective, so that we could have an audit committee come into an ODR platform and say, okay, let's look at accessibility. You know, is your process available less than 2 clicks off of the homepage? Is the cost to access the platform less than 5% of the value of the dispute? I mean, we can come up with very specific things, not just questions, but also objective criteria that we could use to evaluate ODR applications in different contexts that would be very targeted to a particular vertical or application type. And I think that it gets us from the perspective of principles to general standards, to specific standards, to actionable, objective, evaluative criteria. It may be, as we say, when we move to AI, the importance of organizations like iCoder and these external audits become much, much more significant because of the lack of transparency on the internal operations of the processes. So, and I don't want to cut anyone else off, but I see Barbara has posted a great question in the chat. So let me just surface this here. Barbara said, I'm interested in consent too, based on Paul's transactional cases, i.e. where people who have a relationship are involved. In live cases, mediators here have to pre-screen the parties individually for risk before any mediation meetings. Would it be possible to manage this process separately? Would it be different from, say, a Skype interview? It's well known that people often don't find it easy to talk about interpersonal risk. So who wants to respond to that one?
If I'm understanding at least part of the question, it sounds like there's a question about asynchronicity, and I hope I'm not misunderstanding. If I am, someone else jump in, or Barbara, please clarify. But I do think that one of the benefits of being able to use technology is being able to connect with people asynchronistically. So I don't see any reason why you can't, just like a mediator might have what we call a private caucus or an arbitrator and meet privately with one party, that you could caucus, and that could happen easily asynchronistically. If we want to trust technology, which so often does a good job, but not always, we also can have different rooms and we could do it synchronistically with one party just waiting for the intervener to return back to them. So that's part of the answer, I think, at least from my perspective.
I think Barbara is also asking about the sort of sensitive interpersonal aspect. I see Barbara, you're a family mediator, and those are some of the questions that came up a lot, I think, in the early years of ODR, and we've actually been hearing them less and less. Interestingly enough, I think Colin said that to me, that family is one of the biggest growth areas for ODR. It was even actually one of the first ODR processes back in the 90s. It wasn't quite what is being offered nowadays. But part of what we see, I think, is that people now, even in very sensitive and to interact from afar. Some people, I always joke about it now when my friends and people closest to me actually call and don't text me. They start with an apology for 5 minutes that, they couldn't text. And this sometimes even on very sort of complex, sensitive, nuanced issues. And you see that many of our discussions, interactions, engagements, and even arguments take place online, often about sensitive stuff. And once that happens, I think there is no real reason to think that even sensitive resolution efforts cannot take place online as well.
Just to add to that, I think I think Barbara is mentioning pre-mediation kind of screening for risk, which happens quite a lot for family mediations. We're trying to assess also is there any risk before seeing whether mediation is possible. So Barbara, I believe, has elaborated. A report here recommends tightening the pre-mediation screening. We have already carried this, although we have carried this out for many years, right? So probably the question is whether this kind of risk assessment, is it suitable to do it online? Will you be able to fully assess and comprehend all the risks? And will people be able to share freely? So in terms of people sharing freely, I think what Orna, Colin, I guess Noam is also online, has written a lot about that, right? In terms of media richness and the impact of it. In family matters, whether it be asynchronous, say by chat messages, asynchronous kind of messaging, as well as perhaps more real-time video conferencing, it seems that there's a big potential there, right, to really grasp lots of things, to communicate, reach personal matters. Perhaps the part about pre-mediation screening, when you're looking at other things, say risk of violence, whether the person is vulnerable, I'm not so aware about whether that is being done currently online. or whether people are more comfortable with doing that face-to-face so that you can really assess more holistically. But insofar as we're talking about, say, the mediation process, doing it online, that I think that is really being done, and there are great gains to be done, to be reached from doing that in an online context.
I would agree, and for me, the video conferencing piece can be crucial for helping assess risk and build connection. The other thing is, again, as a practitioner, someone who used to do family mediation, I guess I would also say, thinking about risks for ourselves as well. When we're promising confidentiality, what technology are we using? Can we really guarantee, you know, what happens? When I take notes and then I shred them at the end in front of the client, then there are no more notes. But what happens to the conversation? I'm promising that it's confidential. What if my client or the disputant is videotaping that? So I think that it can be incredibly helpful, and video conferencing can make it possible to do some risk assessment and build a connection with the disputants. And at the same time, this brings up these questions around risk for even the mediators that are worthy to think about.
Yeah, and if I could pipe in too, this is kind of a shameless plug. I pre-recorded one of the sessions for Cyberweek with Gene Sternlight from UNLV, who's written a great article called Pouring a Little Psychological Cold Water on ODR. And Gene's expertise is all about human psychology and dispute resolution. And I think what Barbara's question, it all ties together because it gets to this question of consent, informed consent. And I think it's, what Gene talks about in her article is that there's a temptation through the use of technology to sort of ignore some of the more complex aspects of human psychology. And I think in face-to-face mediation, we have done a lot of pre-work to ensure the parties know what they're getting into so that they aren't surprised in the middle of the process. And then we can evaluate whether or not we think this is a good fit with the needs of the parties. But it seems to me that some of these ODR mechanisms are so highly automated, particularly AI-based, people just want to take a big bag of disputes and then pour them into this algorithm without doing a lot of pre-work to educate the parties or evaluate whether or not it's an appropriate fit, that process is an appropriate forum for their particular fuss. And then the algorithm will sort of chew through these cases and maybe get us a resolution in a certain percentage. But I think that does ignore the complexities of human psychology, because there is a process that the parties need to go through to understand what they're getting into so that they don't feel surprised, that they don't feel like they're Charlie Chaplin in the machine, that they're just being ground through all these gears and they're going to come out the other side. So again, if we over-optimize around efficiency, we may overlook some of the important stages around informed consent. And that may be true with a very complex process like an AI, but it also may be true just with an online, synchronous video process, because we're not doing that pre-work. And I think that's what I hear Barbara talking about. So I have to say, please, I don't want to cut anyone else off, but we are at 8:15 Pacific time, which means it's past midnight for Dorcas. And I think this conversation could easily go on for another 2 hours because we have so many interesting things to say. And I imagine that as the facilitator, it's my responsibility to call it to a close because no one else is going to take that initiative. So why don't I just see if there's any last questions before we let Dorcas go to bed? So anyone else have something that they want to raise before we lose this incredibly valuable panel? Okay. Going once, going twice. All right, why don't we call it there? One of the sad things about these online processes, as I've noted, is you don't get to hear the peals of applause from the audience afterwards. But I will give you a little applause on behalf of everyone else because they're all
Let's all give ourselves applause.
That's right. That's right. Maybe I should record just an audience going nuts, and then I can play that at the end of the session. But this was a fantastic
sitcoms applause.
Exactly. A laugh track. But this was great. This was really great. And I've recorded the session, so I'll edit it down and we'll post it. I think a lot of other people, some of our Indian friends in particular, where it really is absolutely the middle of the night, they're very eager to hear some of this as well. But thank you very much to all the panelists. This has been a wonderful session, a great contribution. And thank you, everyone. Have a great day. And hopefully we'll see you at some of the other events this week that are happening.
Thank you all.
Thank
you, Colin.
Okay. Thank you, everyone.
Bye.
Okay.
Bye-bye. Good evening, good afternoon.